if you are a spouse of a British citizen and you are outside the UK, or even if you're already here in the UK, this is a very important video to watch. Hello, my dearest friends. Svetlana Shlapak, the founder of UKVisaSuccess.com, is here. In this video, I explain what happens if after the parties made the application, their visa application, either entry clearance application from outside the UK or here in the UK, and there was a change of circumstances, of the financial circumstances, where, let's say, the sponsor changed their job, or they switched from their employee status to the self-employed status. So this video gives these really important answers, and also at the end of this video I explain how you can get further help with understanding the financial aspect of the application if that is needed. So let's begin. Okay guys, before I explain the rules, I would like to give you a case scenario. John, a British citizen, married Gwen in January. Gwen is a foreign national residing outside the UK. In February, Gwen applied for a UK spouse visa to enter the UK and live with John on a permanent basis here. At the date of the application, John was working at, let's say, XYZ Architects Limited for nearly 12 months. His gross annual salary was £30,000. However, in April, John decided to leave this company and he created his own business and registered with HMRC as self-employed. So just to draw attention here that they've applied in February, and in April, before the decision maker considered the application, he stopped being an employee and he became a self-employed person. And just to remind you guys that those who are self-employed will need to provide documentary evidence confirming their income for the past either 12 months or 2 years, so it depends on their circumstances. In June, the decision maker refused Gwen's application, and according to the refusal letter, they said that allegedly John did not provide a letter from his employer confirming his salary, length of employment, period showing the level of salary paid or employment type, and amounts shown on the payslips differed from those paid into the bank account from June onwards. Also, in the refusal letter, the Secretary of State mentioned that she did not find any exceptional circumstances in John's and Gwen's case which would render refusal a breach of Article 8 of the European Convention on Human Rights, because it could result in unjustifiably harsh consequences for her or for her family. So what John and Gwen did, they appealed against this refusal. The appeal took place exactly a year later after the application was refused. The First-Tier Tribunal judge dismissed the appeal. The judge did confirm that John met the financial requirements at the date of the application. However, in his opinion, in judge's opinion, it was rather irrelevant for the case because the entire legal position, as he said, changed when John had left his salary employment to become self-employed. So the question here is, if John and Gwen were to appeal against the First-Tier Tribunal judge's decision, what would happen next? Would they succeed, or are they doomed to either live separately or together but outside the UK? The most exciting part of this story is that we know precisely what happened in this case, because the Upper Tribunal just reached a decision on a very similar case. Okay, I would like to give you details of this case. After the refusal of the application, which is very similar to Gwen's case, Ms. Begum, the appellant in this particular case, applied for permission to appeal to the Upper Tribunal. And what they did, they first of all applied to the First-Tier Tribunal to get this permission to appeal further. However, such a permission was refused. So what she did afterwards, or rather her solicitors did, they applied to the Upper Tribunal directly and they asked for a permission to appeal against the First-Tier Tribunal. And again, such an application was refused. And then Ms. Begum had no choice and she applied for permission to judicially review the application. And the High Court granted Ms. Begum permission to apply for judicial review, which they did, and the High Court quashed the refusal of permission to appeal. So they found that the First-Tier Tribunal and the Upper Tribunal were wrong in refusing Ms. Begum a permission to appeal. So when the High Court quashes the decision, what happens? The application goes further and the Upper Tribunal is under the obligation to decide the case afresh. And before analyzing this case further, it is absolutely crucial to understand the rules governing the financial aspect of British citizen partner entry clearance applications. And guys, in this video, I'm going to give you a summary of these rules. However, if you would like to have a deeper understanding of these rules and you would like to know how to avoid the refusal of the application because of its financial aspects, I strongly suggest that you watch the online course which I've created for those who are outside the UK and those who would like to understand how to meet the financial requirements. The course is called How to Meet the Financial Requirements of Your British Spouse Visa Application when applying from outside the UK, and you'll get the link to this online course below this video. Okay, so just going back to the immigration rules, to the summary. If the sponsor, who is a British citizen partner, is an employee, adds the date of the application, and as I said, there may be so many circumstances, and therefore in this video I'm only concentrating on those who are employees. So if a sponsor is an employee, what they need to do, they will need to first of all confirm that they were genuinely employed at the date of the application. Secondly is that if there is only one applicant, there is no children in the application, then the applicant earns at least £18,600 gross. And if the sponsor was with the same employer for over 6 months, then they will need to produce evidence confirming their genuine employment and the level of the employment and the type of their employment for the past 6 months. However, if they were with the same employer for less than 6 months, again, we are only talking here about the employees, not self-employed people, then they will need to produce evidence confirming their income for the last 12 months. And it is also generally accepted that British citizens' partner applications usually attract an Article 8 element. Article 8 of the European Convention on Human Rights confirms the right to respect for persons' private and family life. And when deciding appeals involving Article 8, judges usually need to follow the process of questions and answers set in the Razgar case. And I will summarize these questions for you here. So there are 5 questions, and the first one is, will the proposed removal, or if the person is outside the UK, a refusal to admit, be and interference by a public authority with the exercise of the right to respect for his private or a family life. So it's either private or family life. And then the second question, if the answer is affirmative to this question, we need to ask ourselves the second question. The second question is, will such interference have consequences of such gravity as potentially to engage an operation of Article 8? And again, if the answer is affirmative to this question, then we need to move further and we need to ask ourselves question number 3. If such an interference is in accordance with law. Again, if the answer is affirmative, then we need to ask question number 4. If so, is such interference necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others? And the final question, if we answered this question affirmatively, if so, is such interference proportionate to the legitimate public ends sought to be achieved? So at the second hearing, when the Upper Tribunal considered this case, the judge Lane asked himself two questions. First of all, does the decision maker need to assess the sponsor's financial circumstances only at the date of the application? And the second question he asked himself, did the refusal of the application breach Article 8? And Mr. Justice Lane, who decided Ms. Begum's case, answered both questions affirmatively. And I think it's important for you just to give you some extracts from what he said. He said it was well established that the rules were to be given their ordinary meaning. EECP 3.1, which stands for Eligibility Entry Clearance Partner 3.1 rule, required the applicant to provide a specified evidence from the sources listed of a specified gross annual income of at least £18,600. Then Eligibility Entry Clearance Partner 3.2 rule provided that only certain specified sources of income would be taken into account when determining whether the financial requirements in paragraph Eligibility Entry Clearance Partner 3.1 was met. And then he continued by saying that none of those provisions could be properly construed as imposing any sort of ambulatory requirements to continue in the relevant employment beyond the date of the application. I think it's crucial a sentence here in the judgment. And that conclusion was reinforced when one examined paragraph 13 of Appendix FMSE, which is another appendix which tells us which documents should be provided together with the application. And Mr. Justice Lane said that this paragraph was firmly focused on the past 6 months, or in some cases 12 months, as I've explained before. So if someone was with the same employer for less than 6 months, then they will need to provide documents covering 12 months preceding the date of the application. Paragraph 27, he said, provided that an application for entry clearance is to be decided in the light of the circumstances existing at the time of the decision. And finally, he said that since the rules had been framed in such a way as to fix the relevant financial requirements at the date of the application, it did not enable the Secretary of State to refuse an application on the basis that the evidence employment has ceased after the date of the application. So, in other words, Judge Lane confirmed that the decision maker could only look at the party's financial circumstances at the date of the application. It's absolutely fine for the Home Office to make certain inquiries to ensure that the employment is genuine. However, they cannot go beyond the date of the application. And Judge Lane also confirmed that the refusal of the application amounted to a breach of Article 8. He said that the only real issue was whether the interference was proportionate to the legitimate public and sought to be achieved. So let us have a look at the Razgar questions again. He answered the first 4. So the most important question for him to establish whether or not it was proportionate, and Judge Lane said it was disproportionate, and therefore he allowed the application on Article 8 grounds. So this Ms. Begum's case provided some much needed clarity. It confirmed that sponsors have the flexibility to change jobs whilst a spouse visa application is pending, and the parties need to prove that they meet the requirements, the financial requirements at the date of the application. However, guys, the saddest thing here is that such a victory came at a huge expense, the parties' valuable time. And let me walk you through how long it took them to prove that the decision was incorrect. So the parties got married, and by the way, this is a real life case scenario. So the parties got married in December 2016. Ms. Begum applied to join her husband in February 2018. So the application was refused on 7th of June 2018 by the Home Office, and the First-Tier Tribunal dismissed the appeal 1 year later on 24th of June 2019. Then the First-Tier Tribunal refused permission to appeal on 30th of September, and the same thing happened from the Upper Tribunal and on 10th of October 2019. And only on 10th of December 2019 the permission to judicially review the application was granted, and the appeal was only allowed on 12th of April 2012. Guys, despite the fact that they win the appeal, this particular couple lost 3 years from their life. So I'm not quite sure what's happened there, whether the sponsor was living together with the applicants, so they lived outside the UK, and it would be really sad if they just spent these 3 years apart. So when preparing to submit your entry clearance British partner visa application, you need to generally meet 3 requirements. The first one is the validity requirements. The validity requirements is all about following the correct procedure. Then you will need to meet the suitability requirements. It's all about proving to the decision maker that you are of good character, and usually applicants don't have any difficulty doing so. They are struggling with these elements, the eligibility requirements, which consist of 3 elements: the relationship requirements, the financial requirements, the accommodation requirements, and the English language requirements. And this is where the majority of applicants struggle. They struggle with the financial requirements. They either have difficulty proving that they meet the financial requirements, or they, as in this case, showed some documents which were not persuasive enough for the decision maker. Because if the decision maker was happy with the documents which were provided, the refusal would not happen in the first place. And therefore, for those who are outside the UK and are thinking of making the application, I strongly suggest that you concentrate on, first of all, ensuring that you meet all these requirements, and secondly, gathering enough strong evidence to prove that. And to help you with the financial parts where a lot of people struggle, I've created the online course, as I mentioned before, which you can get access to if you click the link below. So guys, it is a very optimistic case, and I'm so pleased that you found this video and you're watching this. I would like to invite you to first of all share this video with someone who is thinking of making the same application. Secondly, please, if you like the video, if you found this helpful, please give me a thumbs up, and also share this with anyone who can benefit, because who knows, maybe this video will help someone with the refusal of their application. Thank you so much for watching this video, and I'll see you next week. I would like to invite you to visit this page, ukvisasuccess.com/more, where you'll find plenty of free immigration resources explaining various immigration rules. And I also invite you to subscribe to a new, very, very succinct and short newsletter where I'll be updating you on various changes in the world of UK immigration law, and also I will be sending various exclusive invitations to the members of ukvisasuccess.com community. You'll only be able to get these offers if you are subscribed to this newsletter. Have an amazing week, guys.